Testing. Good morning, members. A forum is present. I call to order the meeting. Item 1, information papers issued since the last meeting. There is none. So that's it for the first item. Items for discussion at the next meeting. The next meeting will be held at 4:30 p.m. on the 5th of December. Only one item has been proposed by the administration, that is LRC Secretariat, progress on the systematic review of statutory laws of Hong Kong. The only item proposed. If you have any other suggestions, please send your proposals to the Secretariat before 5 p.m. this Friday. I will consult the administration and make a decision. I will not dwell on this item because we have 3 items today. Time is very tight. So if you have any proposals, please make them by 5 p.m. this Friday. Item 3, arbitration outcome-related fee structures for arbitration or OFRSA rules. 2 papers have been issued. The first one, CB-4 923 2022-02, paper provided by the administration. The second paper, CB-4 923 2022-03, that is the background brief prepared by the Legislative Council Secretariat. Now I will invite the representatives of the DOJ and the 2 law associations to come in. Members, if you would like to speak, please press the Request to Speak button.
Hi.
Now I extend my warm welcome to Mr. Clifford Tavares, Principal Government Counsel from the DOJ and his team. I also welcome members of the Advisory Body on Outcomes-Related Fee Structures for Arbitration, Ms. Catherine Sanger, and Dr. Benny Low. Also from the Bar Association, Ms. Kim Margaret Rooney, and from the Law Society, Mr. Roland Tong, Vice President, and Mr. Huen Wong and their team. Now may I first invite the representative from the DOJ to walk us through the paper briefly. Thank you. Chair, members, the Arbitration ORFSA Amendment Ordinance 2022 was passed by LegCo on the 22nd of June and gazetted on the 30th of June. It aims to provide that certain agreements using ORFSA are not prohibited by the common law doctrines of maintenance, champerty, and barratry, and to provide for the validity and enforceability of such agreements, and to provide for measures and safeguards in relation to such agreements. Concerning the reform measure, the government has adopted the reports and the recommendations are made by the LRC last year. The highlight is to add Section 10D to introduce 3 types of officer agreements. The first one is the conditional fee agreement, or CFA, 2 damages-based agreements, DBA, and 3 hybrid damages-based agreements, hybrid DBA. Various sections have come into effect on the date of Gazetto. The remaining parts will come into effect on the date appointed by the Secretary for Justice published in the Gazette. According to 10B, the advisory body was appointed by the SJ to monitor and review the operation of the provisions on officer and to exercise the relevant power under Section 98 Sat M and to make rules to specify the general and specific conditions for the OFS agreements. After consulting the public, we agree that we should adopt the recommendations made by the advisory body, and the draft rules drafted by the advisory body were widely accepted by the industry. The drafts are set out in Annex 1, and the responses from the two law associations and the government have been set out in Annex 2. The specific rules are set out in the paper. There are 6 parts with 9 rules, including that officer agreements must must comply with general conditions. For example, the agreement must be in writing and signed by the lawyer and the client. It must state the arbitration or any part of it which the agreement relates, the circumstances where lawyers' fees and expenses are payable, and also grounds for termination. And it also sets out the uplift element cap for CFA, and for DBA and hybrid DBA, and the cap is also set. And also for multiple DBA and hybrid DBA, which have been entered into, the rule also provides for the maximum aggregate sum of the DBA payments. And also the rules provide that lawyers must explain to clients in clear and accessible language the nature and operation of the OFRS agreements, and also the general and specific conditions, and also the rights to terminate the agreement on grounds of material breach or unreasonable behavior. This is the minimum safeguard for both parties. However, lawyers and clients are free to enter into more protective terms. The rules are not exhaustive. It aims to strike a balance between the freedom of contract and protection. We agree that we have to conduct more promotion and also training about the new regime. In September, we have the advisory body has held 2 workshops for members nominated by the 2 associations. And also, we will start a train the trainers promotional regime, and also in the upcoming Hong Kong Legal Week 2022, we will promote the arbitration system in Hong Kong. We also urge the 2 associations to update the guidelines to tie in with the new rules. Now we plan to introduce the rules into Legislative for a negative vetting procedure on the 16th of November. With the support of the 2 associations, we are hopeful that the rules, together with Divisions 3, 4, and 7 of Part 10B of the AO, can come into operation on the 16th of December to complete the full implementation of the officer regime in Hong Kong to benefit arbitration users, the legal sector, as well as the overall development of arbitration services in Hong Kong. We understand that if there is the need to extend the scrutiny period to by 21 days, then the effective date will become in January next year. Now, after the implementation of the regime, we will further promote the regime and continue to work with the legal and dispute resolution sector to develop user-friendly and practical legal guides and tools, as well as boilerplates to help the industry, so that the regime can be widely implemented in Hong Kong. We'll be pleased to answer your questions. And also the 2 members from the advisory body will also be able to answer your questions. Thank you very much, Chairman. Now may I invite the Bar Association, that is Senior Counsel, to give us your views. The Bar Association is supportive of the draft rules. I also thank the DOJ for taking on board our recommendation and suggestions on the rules, especially the meeting held between the DOJ and the Bar Association on the 7th of October. We have already established a task group to update our guidance in accordance with the new rules, and it will be completed by middle of the month. We are also conducting a series of trainings and seminars to explain the new rules to our members. Thank you. And may I invite the representative from the Law Society of Hong Kong to give us your views as well. Thank you, Chair. I would like to invite our past president and chairman of Arbitration Committee, that is Mr. Hyun Wong, to give his views on the ORFSA rules, and then I will talk about our operational guides and updates after the implementation of the rules. Mr. Wong. Thank you, Chair. On behalf of the Law Society of Hong Kong, on the OFRSA rules, I would like to give you our views. We thank the DOJ for the draft rules. In principle, we are in full support of that. We support that Hong Kong has to implement the OFRSA regime as soon as possible to maintain our competitiveness as an international dispute resolution center. We believe that it can enhance our lawyers' overall competitiveness in the industry, so that we can compete with other competitors in the world on equal footing. Now, with better prospects, we can attract more legal talents from the mainland and overseas to Hong Kong, and then to attract more clients to choose Hong Kong as an arbitral seat and bringing more business opportunities to other related sectors. Most importantly, with our efforts, we can consolidate Hong Kong's leading position as an international arbitration center. However, we have also noticed that legal practitioners in Hong Kong are not very familiar with the OFRSA regime, because this is new on the horizon. So we, as well as the government, should give them relevant support, because the new regime is sort of challenging for them. The reason I say that is that, according to other jurisdictions' experience, the users of such OFRS regime are scalable business clients. We don't often see retail clients choosing the fee structure. These are usually large companies with in-house lawyers as consultants. So when entering into such agreements with lawyers, these clients also have to be very careful every step of the way. So these corporate clients have abundant resources in terms of financial resources and legal resources. Still, we have to offer them with the highest safeguard possible, because they are the clients after all. I just want to point out that they are not as vulnerable as ordinary citizens. We believe that as the beginning of the implementation, we would not see any retail or clients. They would be usually major corporations or institutions. Now, there are international lawyer firms who are very experienced in such a fee structure. They have hands-on experience on the regime. But besides these law firms, most of our law firms, which are SMEs, are definitely inexperienced in the fee structure. Because of that, we think that the OFRSA rules must strike a balance between protecting the interests of the clients and the lawyers as well. Both of them should be entitled to safeguards. we propose that the government should provide support to the legal sector in Hong Kong through other means so that we can enjoy sustainable development.
I don't want to spend too much time in details. Let me cite some examples. For instance, our Law Society has raised a request. At present, there is a 7-day cooling off period. Within this cooling period, the client can terminate the agreement. But then we asked the question, can we also enjoy this cooling period? And the answer was no. You have to write it down in the agreement. The Law Society or the lawyers would not enjoy this cooling period. You have to write down all this sort of conditions that in case you want to terminate the agreement. So this is a kind of unfair situation. In other words, the clients can enjoy this 7-day cooling period, but then the law firm cannot. If within this cooling period, the law firm finds that it wants to terminate the agreement, it would not be able to do so. Well, sometimes the lawyers might find it difficult to handle the clients, or for some reasons they want to terminate the contract. They couldn't do it within the cooling period. You have to look at how you have drafted the agreement, whether you have put into such a condition so that you can enjoy this flexibility of terminating the agreement. Otherwise, you will be in trouble because you cannot terminate the agreement within the cooling period. But then the clients can enjoy such freedom. Another example, it is stated that we have to clearly explain the contents of the agreements relating to our fee structure and the true nature of the system, the fee structure, the operating system. We have to very carefully explain these details to our clients and have it written down in the agreement. However, it has. I'm sorry, Mr. Wong, could you be brief? All right. So I think, if possible, we have to delineate it more clearly. What does it mean by clearly explaining to the clients and so forth? Well, finally, in spite of these drawbacks, we have given our support in September to the DOJ. We have attended the workshop organized by DOJ, and we have raised our comments. Well, the points that I've just raised are just some of our suggestions. I hope that in the future we could have some response from the DOJ, and hopefully these kind of situations can be rectified. Thank you very much. Mr. Tang, you have supplement? We have about 2 minutes left. All right. We just want to point out that in March 2022, the bill was submitted to the LegCo, and we have a working group on our operation manual. We are considering how we could make amendments accordingly to the first version of our operating manual, so that we can, as soon as possible, have these OFSA regime in force in Hong Kong. And recently, our working group has also received, well, after receiving the draft of the amendment, we have conducted meetings, and we have also drafted some amendments accordingly. And on last Friday, the chairman of the working group has submitted to our standing committee on all our draft amendments, and then eventually our executive committee will go through these suggestions and amendments, and we will submit it to our members in December by means of a circular. We have 4 members who have pressed the button, now 5 who have pressed the button to speak. I think we can have 4 minutes each. Please put forward your most pressing points, because at the beginning I might be more lenient in controlling the time, but then when time is running out, I will be more stringent. Okay, first, Mr. Lam Sen Kung. Thank you, Chair. I think this proposal is very important to the implementation of the OFSA regime. The two professional bodies have also given their comments, and the administration has responded to their views. I just heard about the views raised by the Law Society regarding the cooling period. In addition to that, I hope that both associations could also tell us more explicitly whether they are satisfied with the response of the administration so far, because we're going to put the rules into LegCo for negative vetting. In the meantime, we would also further collect the views of the two associations, especially for those who are experienced in arbitration. But I really hope that I can hear directly from two associations their response and their views regarding the reply of the government so far. There's just one question, that's it. I'd like to hear from both associations whether they are happy about the response of the administration, in addition to the cooling off period. The Law Society first. Well, I don't have enough time, but I'd like to cite one central point. I think the DOJ has been trying to dodge the matter of setting down very clear stipulation of the agreements. The DOJ just keeps saying that, well, just try to use it. Let's have it implemented first and see how we could rectify it or refine it. So this is their attitude. So what we could do is just to raise our points to the DOJ. We could only hope that the DOJ could keep a very close eye on how the implementation situation goes. Well, actually, you could talk further with Mr. Lam on this issue. Yes, okay. Mr. Mo, the Bar Association is satisfied with the rules. DOJ, any supplement? Thank you very much, and thank you for your views. As pointed out by the Law Society, indeed, we hope to have the regime in place ASAP, and then after being implemented, we will keep a close eye to see whether there are some areas that need refinement. Well, of course, we would also spend more time thinking about how we could better train the practitioners about this new regime. Well, indeed, this is not exhaustive. We just want to strike a balance between respecting the freedom of contract and also protecting the relevant parties. And also when compared to other jurisdictions, for instance, Singapore, we have actually tried our best to make these regulations as comprehensive and flexible as possible. We do have a monitoring role to play. We will keep an eye on how OFSA is being implemented. And if in the future we find that there are rooms for improvement, we will, of course, definitely will continue to improve it. Mr. Yim Kong, thank you, Chair. Well, I support this proposed rules. I have a small suggestion to make. Well, basically, the general firms may not have lots of experience about arbitration. They're not familiar with the arbitration rules. So I suggest that there should be some sort of supplementary explanation. For instance, before entering into agreement, how could both parties handle disputes or address issues? Well, for instance, the rules could provide for the handling of two different situations. First situation that agreements have been entered into. Second situation is before the entering of the agreement. There should be this kind of supplementary note to the rules. My second question is that in Division 5D IV, this stipulates about the fee structure. But then it is not stipulated what should be done if agreement has not been entered into. So is this a general condition or a specific condition? Thank you, Chair. Thank you, Mr. Yim. Regarding your first question, the design of the rule, especially divisions 4, 5, and states that there must be a kind of special or general condition and also specific condition. Only with these conditions can officer regime be implemented. So regarding of the three types of agreements, it is stated that the agreement must clearly state how the fees are to when or under what circumstances the expenses are payable. So it is not just to encourage people to enter into the agreement, but then it is a must. So these are the general conditions. Especially in 5B4, it states that it should be the agreement should state whether barristers' fees are part of or in addition to the DBA payment. So this provides for a platform for both parties to understand how the agreement works. Thank you. Representatives from the two associations, any supplement to make? Yes, I agree. That in drafting the agreement, it should be clearly stated how the expenses are or on what circumstances are the expenses payable. Next, Ms. Carmen Can. Thank you, Chairman. I notice that the advisory body, according to the AO of 609, has appointed 3 members till the 2025 July on its committee. I'd like to know that in designing these rules, what are the general principles of the advisory body? And also, in reviewing its future operation, does the advisory body has a plan of how it is going to review the operation of the rules? And also, I noticed that there are 2 training sessions for both associations, but I think it's really far from adequate. As reflected by the Law Society, I also agree that there should be more training and better promotion, especially there are different sizes of law firms in Hong Kong. So before the implementation of this regime, I think we really have to make sure that law firms of all sizes understand the contents or the details of these rules, and we have to make them all prepared for it. I wonder if the DOJ could do more in promoting and also in providing training. Thank you, Chair. Regarding the advisory committee, regarding its establishment or the criteria of its review of the regime. A 3-month public consultation had already been conducted, and we have received over 20 sets of views and comments. Some are from the general public, some are from law firms, some from the Chamber of Commerce, and so forth. They are also from legal bodies as well. So there is a wide consultation have been conducted. So the advisory body found it adequate to base on the views collected by the LRC to conduct its work. Well, of course, we're not following blindly the recommendations of the LRC. we did have internal consultation, and after coming up with the first draft, we also had solicited views from the advisory bodies and also members of the legal profession. And based on these further consultations, we drafted the draft rules and then consulted the two professional bodies. They had also given us some response.
So actually, our first draft has been amended for several times before we come up with this final draft. We fully understand Ms. Carmen Can's question. There will be continuous monitoring, but as Ms. Khan is aware, the draft rules were just devised in July. So with the draft rules, we can fully implement the regime. The next stage is more promotional campaigns and further training activities in the middle of next year. At those training sessions, we will canvass more views from the industry in terms of the operational details. And the next step after that will be preparing simple tools like boilerplates and templates. And then with more practical knowledge, we can have a very clear timetable. Any supplements from the Law Society? I have one suggestion only concerning the advisory body. Can the administration ensure that there are sufficient representation from the SMEs? Next up, the Vice Chairman, Ms. Eunice Yung. Thank you. Well, actually, I am quite worried after hearing what Mr. Wong said. Barristers can enter into the agreements on their own. Like Mr. Hyun Wong said, if the SME and the major companies, lawyers are also worried, then what about barristers? Because we have no support at all. In terms of implementation, has the DOJ studied the example of other jurisdictions on the litigations involving OFRS agreements and an estimation of the situation in Hong Kong? Yes, we understand that barristers may have even more concerns because usually solicitors would act as the in-between, a go-between between barristers and their clients. So we have already conducted a workshop specifically for barristers. The question has been touched on as the workshop. Barristers are allowed to enter into officer agreements directly with their clients. So there may have to be amendments to the professional guidelines issued by the Bar Association. And we really want barristers to take the step to enter into OFRS agreements. So when there are practical issues and there are actual concerns raised by the barristers, we will consider them and enhance the regime. Well, what about past studies on other jurisdictions? Thank you for reminding me of that question. In the LRC's report, the LRC has studied the situation in other jurisdictions with officer regime, especially the UK, which has a long history of OFRS agreement. So will there be a lot of satellite litigations caused by the system? Well, several years into the implementation of the regime, there hasn't been a major issue about satellite litigation. However, after some time, the number would rise. So back in year 2007 or 2008, Hong Kong has studied the feasibility of an OFRS regime for not just arbitration, but civil litigation as a whole. But we think the time was not mature because there might be conflicts of interest and conflicts between lawyers and the clients and so on. Today, when the RSC revisited the issue, in other jurisdictions, the OFRS system has been improving. So the previous concerns over satellite litigations would not occur in the field of arbitration, given that appropriate rules are in place. So we will ensure that we are ensuring that there are enough safeguards to ensure the system can run smoothly. Next, Ms. Maggie Chan. I declare my interest. I am a member. I'm the founding member of the Association for Lawyers, for SME lawyers. We understand that the OFRSA regime is very important in enhancing Hong Kong's status as an international dispute resolution center, and this is very important in aligning our position with the country's strategy. We want to attract more arbitrators to establish a presence in Hong Kong, and we want to attract overseas talents to Hong Kong in terms of arbitration. However, it seems that the new rules will change the entire scenario. I'm extremely worried that the cases will go to the multinational law firms. For the SMEs in Hong Kong, which constitutes 80 to 90% of the legal industry, will be shut out. So Mr. Hyun Wong, a very respected member of the association, has voiced his concerns. I totally agree with him. As the founding member of my association, I also want to voice my grave concerns. Now, in the PA, it mentions that we have to maintain the growth impetus. We have to compete for talents from the global arbitration industry. However, they would just become competitors. We should nurture our own talents. All along, the DOJ and the government has neglected nurturing the lawyers in SME law firms in Hong Kong. So we are always talking about KPIs. What about the KPI in this regard? I have been representing the interests of SME lawyers for a long time. There are always one or two seminars or talks, and the government would call it help already. There is no sustaining efforts to help us develop. So I want KPIs. So like Mr. Hyun Wong said, the advisory body must comprise representatives from the SME industry. And the representative must be given a say. Now, in terms of accreditation, the government should allocate resources to give accreditation to SME lawyers so that we can join the game as well. Otherwise, it will hinder the growth of our industry because the cases will go to the big firms only. So there seems to be concerns voiced by the two important law associations. So I would like the Principal Government Council to give us a detailed reply. Thank you. I appreciate your concerns. From our perspective, the implementation of the officer regime is to help the dispute resolution industry to grow as a whole. For major law firms, especially those with international branches, they would be at a better position to benefit from the system because they have experience. But from our policy perspective, for SME law firms, the new system can also help them to join the market. For a very complicated case which need a lot of financial and human resources, with the OFRSA regime in place, even an SME law firm can take the case because of the alternative funding option with the client. Of course, you have to also consider the experience of the law firms and the expertise of the firm. There are other factors to consider. But from the policy perspective, we think the regime can also help medium-sized law firm to join the fray. So, of course, the DOJ will keep a close eye on the matter, and the advisory body will keep monitoring. If any problems are identified, we will consider amending the legislation and also provide tailor-made training for different practitioners. Thank you, Chair. Can I have another go? Yes, please be brief. Chair, I think what the DOJ said are just words to appease us. Now we have a government which is actively intervening, and we are abandoning the mindset of a small government and big markets. Now the government should take the lead. From what you told me, I don't see any promises to give us better training and support. So, given the hands-on attitude of this term of the government, you should set a KPI to help us. Or you may be saying that our legal industry is getting more internationalized, but 90% of our practitioners will not be able to take those international cases. Well, you don't have to give us a reply, Secretary. Just take note of the view. I will draw a line here. The last member will be Dr. Junius Ho. Thank you, Chair. So the OFRSA rules have been a long time coming, but it is underwhelming. There are many restrictions. For example, Part 2 agreements must be in writing. Of course, that is right, but there are lots of restrictions to the form of agreements. You need the clients. You need to advise the clients to seek independent legal advice. You need to specify the lawyers' fees and expenses payable, and also the uplift cannot exceed 100% of the benchmark fee. And also, there are heavy indemnity burden in Part 3 and Part 4. These are unpractical. Well, I think the DOJ think all lawyers are thieves. Back when we were scrutinizing the bill to amend CAP 607, Mr. Guo Wenheng was the chairman. It said by nature of the lawyers, sorry, Dr. Junius, please use Chinese because I'm not very good at English. Yes, Martin, you are right. I should speak in full Cantonese. Chair, the ordinance was unfair to lawyers. So we asked why lawyers were shut out from it. Well, everyone could have a go at it, but not lawyers. At the end, we moved a committee stage amendment. However, in the end, lawyers who were involved in the case were not allowed to enter into a CFA as well. Now we have this ORFSA agreement regime. The reason of its existence is to restrict lawyers' freedom to enter into agreements with those sophisticated clients. Everyone is a big player, the deals are always massive. So why are you setting so many rules to restrict us? We want liberation. So on conditional fee arrangements, back in year 2007, the idea was floated. Now in the UK, the system is not a success because there are lots of constraints. There was a lack of financial resources, and the lawyers have to pay out of their own pockets. So you mentioned we are referring to the UK. I think that is nonsense. I am the first lawyer to practice in the GBA. I have attended court proceedings on 2 occasions. The fee model was very brilliant. I don't know why you are learning from a country so far away.
Chairman, I think these rules will cut off over 80% of the local law firms. When you look at the higher rights of audience, among 11,000 lawyers, how many of them could get the higher rights of audience? Chairman, I'm really very upset about it. Are you treating us lawyers as thieves? Why do you have this kind of wasteful rules and restrictions on us? And it's going to be implemented very soon. But then when I look at it, over 80% of the local lawyers will be excluded. I really solemnly like to recommend that Part 1, paragraphs 1 to 6, all these damages do not need to be mentioned. We have PIS. Why do you need to do this kind of redundant things? Why do you want to give us so much restrictions? Thank you, Chair. This is just a view. No, this is not just a view. Well, what I meant was this is not a question. It is a question, a long question, though. Any response from DOJ? Just one point. Thank you, Chair. I'd like to supplement that. In considering the examples of other arbitral seats, well, just now I mentioned the UK because of the interest of time. In fact, we have not just drawn reference from the UK, we have also looked into the situation in Australia, the mainland China, and so forth. So these are the basics for our consideration. All right, thank you. This is the end of the agenda item. I'd like to ask members if you all support that this. Do you all agree to it? No, I object. All right, let me formally ask. For those who agree, please raise your hand. Those object to it? All right, this committee supports. The majority of the members showed support to the rules. All right. Shall I be submitting a CSA, committee stage amendment? Well, this is a bill committee. You're talking about something down the road. They have to submit the bill first, and then we'll have to form a bill committee. And only till then can we decide whether there should be any amendment. Thank you. This is just a panel. This is not the legislative process yet. I'd like to thank the government representatives and also members of the 2 legal associations to attend the discussion of this item. Let's move on to the next item on the agenda. Next item on the agenda is a consultation on cyber-dependent crimes and jurisdictional issues published by the Cybercrime Subcommittee of the Law Reform Commission of Hong Kong. Members will have received 3 papers. 1, CB bracket 4923/2022-04. This is a consultation paper issued by the LRC. Second paper is CB bracket 4923/2022-05. This is an executive summary of the consultation paper issued by the Law Reform Commission. The third paper is CB bracket 4923/2022-06. It is a submission from the Law Society of Hong Kong. Let's now invite the chairman and also the representative of the LRC to enter the meeting room. For those members who would like to speak, please press the button now. First of all, welcome Mr. Alan Leung, Chairman of the Cybercrime Subcommittee of LRC, and his colleagues. We also welcome Mr. Edwin Choi from Hong Kong Bar Association, and Mr. Roden Tong, Vice President of the Law Society of Hong Kong, and his colleagues. Let me first invite Mr. Wong, Wesley Wong, to walk us through the paper. Thank you, Chair. We have been using our consultation paper. I think I would defer it to our Chairman of our Working Committee to introduce the paper to members. Thank you. Our representative from the Law Society of Hong Kong? No, I'm sorry. I'd like to invite Mr. Leung, Chairman of the Cyber Committee Subcommittee, walk us through the paper. Thank you, Chair. Members. The Cybercrime Subcommittee of LRC is very happy to have this opportunity here to explain to members about the contents of our consultation paper. The consultation period has ended on the 19th of October, but then this morning is a good opportunity for us to introduce the content of the paper to you and hear your views. Because of the rapid development of the IT technologies, and we find that there's a rise of cybercrime, we find it necessary to look into the challenges brought about by these rapid development and try to think of what sort of legislation should be in place to protect the interests of the parties concerned. We have also drawn reference from other jurisdictions and also different kind of relevant legislation. Other jurisdictions, including Australia, Canada, UK, Singapore, and mainland China, have relevant legislation regarding these cyber-dependent offenses. In looking into the issue, we have taken into consideration the interests of the relevant parties involved. So the consultation paper tried to strike a balance between the development of the personnel in the industry and also the users, and also their right of not to be interrupted or disturbed. Well, the consultation paper examines 5 offenses. First, illegal access to program or data. We do have the telecommunications ordinance in place, and there is the term telecommunications. But then we find it necessary to update the legislation so that anyone who have illegal access to the program or data, or who have not been authorized to have access to these program or data, they would commit the cyber-dependent offense. And also, if the person has installed a certain kind of software and then try to blackmail the owner, this would also be a cyber-dependent offense. And there should also be a kind of uplifted or also it should be a kind of further crime or aggravated form of the offense. And we also have looked into the defense of reasonable excuse. We would like to hear the views of the public on these. Second area regarding illegal interception of computer data. Well, and also illegal interference of computer data. We recommend that unauthorized interception, disclosure, or use of computer data carried out for a dishonest or criminal purpose should be an offense under the new legislation, and it should cover the entire time. For instance, when the data are being uploaded or being downloaded. Well, we understand that people might have different channels to have access to these data. So we also have studied into whether there should be a kind of defense. And we also have looked into what would constitute illegal interference of computer data. So we suggest that there should be a special legislation regarding this. So that people without a legitimate excuse, if they have access or change the content of this would be an offense, and also for illegal interference of the data. Well, at present, there is no clear definition regarding what is an illegal interference of computer system, with a view to making aligned the legislation and current practice. There might be circumstances that technician may try to go or access into a computer system to see whether there are illegal interference. So we have also studied this situation and consulted public views regarding whether there should be lawful excuse to such a proposed offense. And so with the new legislation, we want to see whether there should be similar clauses regarding the how it would constitute illegal interference, and we want to make available or processing a device or data made or adapted to commit an offense. If a person try to make use of this data to commit a crime, that it should be an aggravated offense. But then we also recommend that there should be kind of a reasonable excuse as a defense should be accepted. This is just a brief introduction of the paper. Your views are welcome. Thank you, Mr. Leung. Now may I invite Mr. Chong from the Law Society of Hong Kong to give us the view of the Law Society. Thank you, Chairman. First, on this consultation paper, the Law Society welcomes it, and we also welcome the initial recommendations made by the LRC. Well, this is to respond to the development of telecommunications and also to protect the users of the computer data. The Law Society notes that there is an increase of cyber-related crime, but then it is also difficult to define whether it is an actual cyber-related offense. According to the police, there are over 14,000 kind of cyber offense this year, and 2.2 billion Hong Kong dollars have been lost in these cases, and there is an increase of 8% of such crime cases. So we also find that the existing legislation related to cyber offenses is out of date. That's why we welcome the recommended proposal of the Law Reform Commission. We have submitted our views in writing to the LLC, which has also been given to the LegCo for perusal in September.
On legislating against computer crime, we have to be very careful. Technological advancements is progressing at a very fast pace. We have to consider scenarios where people found themselves on the wrong side of the law inadvertently. The consultation paper has a very wide scope involving different policy areas. So when a bill is being drafted, wide consultation is needed to canvass the views from different stakeholders. Thank you, Mr. Tong. Next, from the Bar Association. May we have Mr. Edwin Choi, SC.
I'd like to extend our gratitude to both the Subcommittee on Cybercrime and the Law Reforms Commission's Secretariat for their laudable efforts in preparing this comprehensive consultation paper on cybercrime. The Bar welcomes the direction this new legislation is proposed to take. We believe that, given the ever-increasing dependence by our citizens and businesses on the use of computers, the Internet and different communication devices, the need to accord to these stakeholders sufficient protection is clearly present. Furthermore, new species of cyberspace activities previously unimaginable are becoming commonplace every day. These trends, while serving the interests of the community in many ways, also give rise to opportunities for criminals to exploit. We are therefore in agreement with the Cybercrime Subcommittee that there is an urgent need to come up with legislation to combat different forms of cybercrime. Having reviewed some of the case law referred to in the consultation paper, I have the impression that the existing legislation and our common law have been stretched to their limits, and certain nefarious activities just could not fit within the framework set out in our existing criminal law. As to the individual offences recommended by the committee in the consultation paper, the Bar's position is that those 5 or 6 criminal offences identified in the paper requiring new legislation are all rationally based. We accept that there is a need to create those offences in order to criminalize activities such as hacking and phishing more effectively. And some comments on the wordings in the future legislation. We, at the same time, recognize that it cannot be easy to draft the legislation to cater for all eventual circumstances, especially when many advances are being made by the technological sector. Words such as computers, programs, or systems may appear very general. On the other hand, words such as metaverse, etc., may later be seen as only referring to one defunct stage of development in technology. Thus, the law draftsman's task to find the proper and precise wordings and definitions will be onerous. The consultation paper sets out in some details the very clear studies on various other jurisdictions carried out by the subcommittee. They provide valuable insight and analysis. As and when the law draftsman has come up with draft legislation, the Bar shall be happy to provide comments on the advisability of some of the wordings. However, this should be left to a later stage in this process. And there's an interesting discussion in relation to Recommendation 5 concerning free Wi-Fi and potential interventions by commercial bodies. As part of the discussion in relation to Recommendation 5 of the consultation paper, the subcommittee raises the issue on whether interceptions by commercial entities providing free Wi-Fi use should be prohibited or criminalized. We do all now realize that our phones would on their own automatically interact with other telecommunication devices in the vicinity. These interactions seem to involve some mutual interventions between devices or their programs. Thus, on first blush, it may seem drastic to criminalize or prohibit such commonplace interventions altogether. Secondly, the nature and the extent of the interventions vary considerably. One may consent that one's username be identified. One probably would object if one's WhatsApp content were to be copied or downloaded by the intervener. Thus, there may well be a need to strike a balance. When shall we say that a citizen's privacy has been subjected to intolerable invasion? On the other hand, we also have to recognize that the availability of these wireless services is crucial to the development of many businesses' commercial and genuine interest. We therefore endorse the recommendation of the subcommittee that different stakeholders should be invited to give their views on this issue. Now, finally, a word on extraterritoriality and global enforcement cooperation. It is our common experience that cyber criminals have little or no respect for national or jurisdictional borders. With the dramatic advancement in cyber technology, a criminal can intercept or hack computer systems located far away. Thus, there is every need to incorporate a degree of extraterritoriality in our attempt to legislate against cybercrime. We share the sentiments of the subcommittee expressed in Chapter 7 of the consultation paper. In our view, recommendations 11 to 15 concerning the extension of the jurisdiction of our courts in dealing with cybercrime offences are rationally based, and they conform with the general principles of extraterritoriality. We, however, would want to sound a note of caution. It is one thing for our legislature to criminalize an out-of-jurisdiction hacker's activities affecting our citizens or businesses. It is another thing to be really able to catch this hacker. Given the borderlessness of the cyber world, effective enforcement of any legislation would require international cooperation. We must therefore bear this in mind when we consider how this piece of legislation could bring about the protection of the rights of our citizens and businesses against cyber criminals. Let me end this by again expressing our admiration for the sterling work of the subcommittee and the Secretariat of the Law Reform Commission. Thank you very much.
Thank you very much, Mr. Choi. 我哋而家到
Now this is the Q&A time. We have two members, or rather three, who have raised their hands. So 4 minutes each, including questions and answers. Please keep your question within the time limits. Mr. Holden Chow. Thank you, Chair. I thank the LRC for their admirable efforts. Previously, on dealing with cyber-dependent crimes, we only rely on the dishonest use of a computer. It is outdated. There are lots of loopholes. According to previous court findings, you have to prove that you are using another one's computers. If you are using your own computer, even if you launch a hacker's attack, you wouldn't be criminalized. So it is time we do an overall review on the law. I have a question on the other hand. I have read the entire consultation paper. Among the new offences, you have made reference to the 1990 Computer Misuse Act of England. So that was a piece of law to keep the legislation updated with time. Still, it is about unauthorized use of computer data, which will trigger the offense. Well, you may remember we have theft of examination questions cases in Hong Kong. So those people committed a crime within their own authority. So what if these people who have been granted authorization launch a hacker attack in the future? So after the consultation exercise has begun, some business stakeholders have mentioned the scenarios where hackers use the free Wi-Fi provided by them to launch an attack. These businesses are very worried that they would be criminalized under the new legislation. So I would like to hear more on the reasonable excuse or the elements of a knowledge of the activity. Mr. Wong? Well, on reasonable excuse and mens rea, our recommendation is that we would you please speak closer to the mic. Our recommendation is that the new offense would only prohibit unauthorized interception of data and disclosure and use of such data for criminal intent. So there is the criminal intent element, and not just interception, but also disclosure and usage. So it depends on the intention of such interception. If there is no criminal intent, you will not be criminalized. And also whether you have disclosed or used the data, and for what reason are you using it. So one such purpose may be to see where there are heavier foot traffic and where advertisements would be more effective, and what properties would justify higher rent. So these are all commercial considerations. So it would be up to the courts to decide whether the use constitutes a reasonable excuse. So at this stage, we have a lot of difficulties to define what a reasonable excuse would be. On authority, I may have to leave it to the experts. In the cyber world, there are so-called unofficial authorization. There are people who conduct a port scanning, which are often not unwelcomed by businesses. So there are scenarios where the person being hacked would not oppose to the hacking behavior. So would you require a written answer? Well, I would appreciate that if time is insufficient. Yes, please give us a written reply after the meeting. So would the chairman be more lenient so that we can answer the question in full? So let's say a cafe's router has been hacked for launching an attack. Then the business and the customers in the cafe would become victims rather than the criminals. In terms of authorization, once you are connected to the internet, there will be inevitable communications. So these are the underlying protocols, and they are also implied communication protocols. So you are already a part of the communication, and we don't think we should criminalize this kind of use. Ms. Carmen Can. Thank you, Chair. So the consultation paper is about cyber-dependent crimes and jurisdictional issues. Now, the cyber world is vast, and also there is the metaverse. We need over jurisdictional power in our law. So I would like the RLC to give us some idea on your preliminary thought on enhancing international collaboration to make the law enforceable. Second question, can the LRC give us some plain examples to explain how the future legislation can deal with scenarios which we are not equipped to address at present, so that we can better understand the power of the law? And looking forward on fake information and fake news legislation, how will it align with the direction mentioned in the consultation paper? So, Mr. Wong or Mr. Leung, which one of you will answer? Concerning legal policy, I think Mr. Wong would be the person to answer it.
Thank you, Chairman. Regarding jurisdictional issues, we're looking at this from three perspectives. This consultation is just the first part. On the third part, we will specifically talk about jurisdictional issues associated with cybercrime. This indeed is a very important issue because the cyber world is really sort of uncontrollable. And the servers could be set up in different countries, for instance, in country A, but then the social platform, media platform is in country B. So these are the challenges. We consider several issues. First, the incident on the major elements have to be taken in Hong Kong. Second, the victim is in Hong Kong. Third, the perpetrator is in Hong Kong. And third, the attack or the hacked computer is stationed in Hong Kong. And also, it will bring about serious damages to Hong Kong, including damages to the public utilities. Let's say, for instance, a hacker tried to introduce some virus to a Hong Kong public transportation system network, then it will cause serious or major public issue. So this is the elements that we would have to consider. By the time we look into it in greater details, we will then try to see all these elements in greater depth. Regarding crimes committed overseas, can we have the collaboration of the related country? Well, according to our experience, some are cooperative, whereas some other may not be. So we also have to look into whether there should be a double criminality. We have to consider this issue as well. We have to, under the current situation, the perpetrator in overseas have to done something that is also illegal or unlawful in that country. Only then can we try to seek the collaboration of that country. So these are the issues that we have to look into in greater details. Well, this is just the first stage. At present, we're trying to gather public views on our consultation paper. Any supplement from Mr. Leung? Regarding fake news, Mr. Wong, on fake news, there is a definition. And also, there should be relevant legislation against it. Under that circumstances, then it would be a criminal offense, and we will go into the second stage, and that is about the criminal offense committed by the assistance of cyber. These are the definition of cyber-dependent crimes. In other words, the perpetrator is trying to make use of the computer or the cyber web to commit a crime. Next, Dr. Junius Ho. Thank you, Chair. First, I am in support of this regulation or this legislation. The LLC notes the importance of tightening the grip on cyber-dependent crimes. On the one hand, we're enjoying freedom in the cyberspace, but then on the other hand, we have to observe the law. So I agree that the government should protect the interests of the wider public. And that's why I think it is a good thing that we see this updated recommendation to update our legislation. Or, however, I see the description that the description about the crime being committed in Hong Kong and also the perpetrator being in Hong Kong and also the evidence being collected in Hong Kong. It seems that these are the prerequisites. If that is the case, we do not have the right to do anything if the perpetrator is not in Hong Kong. However, we have to know that the cyberspace is borderless. If you set down this legislation and if by the time you implement it, you find that it doesn't give the authority or give the administration the authority to do anything or to enforce the law, then it would be a waste of time. About target program or data being in Hong Kong, This is the problem. Will you consider perhaps when amending this legislation, all the service providers, be they Twitter or Google, no matter where they put their data, will you require these service providers to keep a copy of this data in Hong Kong? We do have the database in Zheng Guan O. If they are going to conduct business in Hong Kong, can we require them to keep a copy of these data in Hong Kong? And also, can we require the relevant jurisdiction to collaborate with us if certain crime, cybercrime, is committed in their jurisdiction? Otherwise, it's just meaningless. It's like a tiger with no teeth with this legislation if you cannot enforce it. Well, I am in full support of the legislation. However, I'm just raising the point about its enforceability. I hope that in recommendation 13, as long as if you know that you can do nothing if the data is not in Hong Kong, I think we should really try to plug the hole here. Thank you. Mr. Leung? Thank you, Dr. Ho. You have raised 3 points. First, about whether the Hong Kong courts can have a jurisdiction. I think there are 5 elements we have to consider. First, it must be a person committing the crime in Hong Kong. Second, the data must be in Hong Kong. And also the victim is in Hong Kong. And also the target computer program or data is in Hong Kong. And also the Perpetrators Act is conducted in Hong Kong. For enforceability, I think we have to spend more time to look into it. Well, for instance, a provider, for instance, Google, if they have offices in Hong Kong, they should abide by the rules of the laws of Hong Kong. Well, it already has a presence in Hong Kong, so it has to abide by the law of Hong Kong. So we do understand that enforceability is a challenge because cyberspace is really global and is borderless. So we really have to see whether we can enforce Hong Kong's legislation in other jurisdictions and see whether we can gather evidence from other countries. Well, these are the challenges that we are facing. I think we have to spend more time to see how we could address these issues. Well, this is just the first stage. It's a consultation paper, so we haven't come into such detail yet. Chairman, I have a supplement to make. It is exactly that we noticed this loophole. That's why I raised this point. Oh, for instance, I hack a computer and then I throw away all the data. Then I'm free. So in plugging this hole, I think you have to require that the person must have a copy of the data somewhere. So if the perpetrator has destroyed the computer, then it will not be possible for you to collect any evidence. Well, perhaps the server is in another country, but then the perpetrator is in another country as well. So this is really a problem. Actually, we could discover the data. I can just get hold of Google, who is the third party, and I believe that they must have a copy of the data. I don't care whether it's in Alaska or anywhere. So you have to trace the source. For instance, the server like Google, I'm sure they must have a copy of this data somewhere. Next, Ms. Vice Chairman. I welcome this consultation paper, and I also note that you have studied the national security law of Hong Kong before coming up with this draft. However, I wonder why don't you use cyber safety or security as a kind of theme, but then you are using cyber-dependent crimes as the theme. And also you're talking about illegal access or illegal interception and also cyber safety. Are we actually trying to ask the public about their views on cyber safety? It seems that the paper is now focusing on what does it mean by illegal interception or illegal access or impermissible access and so forth. And how do we define whether it is lawful or not, and whether there should be reasonable excuses. Well, 20 years ago, I worked on similar case, and I also have made use of data on the cyberspace. And through a kind of phishing website, well, 20 years ago, that was possible, but of course, nowadays it may not be in place anymore. But I believe that some education bodies are still using this kind of method to collect data and also to provide access to other parties who want to make use of those data. So are we talking about cyber safety and data safety, or just illegal use of computer, or also impermissible access of data and so forth? What is our emphasis here? If we are talking about cyber safety, then perhaps we should shift our attention to safety in the cyberspace. And in your legislation or future draft, you should then pay more attention to how we could ensure cyber safety instead of trying to define what is illegal access and what is impermissible use of computer data and so forth. Thank you, Chair. For these 5 offenses, we have taken into consideration the general practice of other jurisdictions. Well, including we have considered the Budapest Convention and also the United Nations Convention on Cooperation in Combating Cybercrime. They also have these 5 types of offenses, and these are the general definitions adopted by other jurisdictions. Well, talking about cyberspace, that's a different thing. It's very wide. The scope is very wide. Interception is just part of it, or illegal access is just part of it. So the prerequisite is to try to ensure cyber safety and to protect the interests of the general public. So all these offenses and all the points that we have taken into consideration are ultimately to protect cyber safety. We have also tried our best to strike a balance between the interests of different parties involved. We understand that we have to protect the right of netizens and interests of persons in the information technology industry, and also protect the public interest and the right not to be disturbed or attacked when using or operating the computer system. And that's why all these illegal interception and illegal interference are included. Well, Chairman, cyber safety, yes, indeed, covers a very wide scope. If we're just talking about illegal interception or illegal access and interference and so forth, these are just part of the scope. We have not been able to cover the entire scope of cyber safety. We're going to have a consultation on cyber safety. Is it the same as the present consultation paper?
Mr. Wong, allow me to supplement. The questions to be dealt with by the Security Bureau are the safety of infrastructure. I mean the cyber security of infrastructure. our focus is different. So the Security Bureau is concerned about the security of electricity grid and so on. So that would be addressed by the Security Council. We are dealing with the wider issue of cybercrime. So there are overlapping areas, but the focuses are different. So I am the last one in the first round. My questions have been asked and answered. That is extrajudicial power and also the challenges in enforcing the legislation internationally. I don't have to repeat my questions. So cybersecurity is one of the key areas of national security. In many places, including our country, and also the United States and Canada, have formulated laws to tackle cybercrime. In Hong Kong, however, we still don't have an individual bespoke law to deal with cybercrime. As a place which is very proud of its security and safety, this is a loophole we have to plug. And also, I share the same concerns with Mr. Tong. We need to do a balancing exercise in balancing the rights of different stakeholders. And second, we must explain clearly to the public to allay the concerns. In the event of legislation, I believe that the public would be more acceptable to it. So these are my own comments. I don't require a reply. For the second round, we have Ms. Carmen Khan. 3 minutes, please. Thank you, Chair. So one scenario is mentioned by Mr. Leung about extrajudicial enforcement. I mean, one criteria is that acts that will or may lead to serious damage to Hong Kong's safety. Say, for example, an overseas launched attack on our infrastructure. So, concerning key infrastructures and cybersecurity, the work would be led by the Security Bureau. Chairman, you also mentioned the importance of protecting national security by ensuring cyber security. So there may be overlapping, but my view is that we shouldn't address the problem after the consultation exercise. The Security Bureau is going to legislate to ensure cybersecurity of infrastructure. Then, riding on the opportunity, we should start considering international collaboration on enforcing extrajudicial power. So that would give us a clearer timetable to address the concern. Second, as per my previous question, are there any examples to tell the public clearly that after the implementation of the new legislation, what scenarios which we cannot deal with right now can be dealt with? So for the last offense, that is making available or possessing the device, I understand that the industry has some concerns. So there will be some devices which will trigger the offense. But there are other reasons for which businesses may have to possess or maintain these devices. So I would invite Mr. Ip to elaborate. To answer Ms. Khan's question briefly, what actions which would constitute an offense right now are not criminalized, and in future they will be addressed. For example, for concert tickets, some people may have written a program to use robots to get the tickets, and also for sports venues. 5 seconds into the application, every venues would be booked. So the law is not very clear as to whether it constitutes an offense right now. It may fall under the offense of illegal interference of computer system in the future. There are also DDoS attack, which is very common for internet service provider. The law is not very clear as to whether DDoS attack is an offense. With the new legislation, it would be sorted out. So the two law associations, do you have anything to add concerning the discussion just now? Okay, thank you very much. If there are no further questions, it is the end for this item. I thank the LRC and the two associations for coming. Moving on to the last agenda item, that is a (2022-23) Judicial Service Pay Adjustment, file reference AW2750100150001. That is the Legislative Council brief on 2022-23 Judicial Service Pay Adjustment. And also we have LC paper CB brackets 4923 2022 brackets 07, updated background brief prepared by the Legislative Secretariat. Members who would like to ask questions, please press the button. I will first invite Mr. Brian Low, the Director of Administration, to give us a briefing. Thank you, Chair. We are pleased to brief members on the 2022-23 Judicial Service Pay Adjustment proposal. The judicial remuneration is determined under a mechanism separate from civil service. The remuneration for JJOs is determined by the Chief Executive in Council after considering the recommendations of the Independent Judicial Committee. If extra appropriation is required, we would seek funding from the relevant authority. Now, for year 2022-23, the Judicial Committee has considered a basket of factors and proposed that for year 2022-23, for JJOs, there would be a pay rise of 2.5%. The baskets of factors include the responsibility, working conditions, and workload of judges, Hong Kong's economic situation, the recruitment and retention, and also the comparable pays in the private sector. The Chief Executive in Council has accepted the recommendations made by the Judicial Committee. We hope that members will support the proposed adjustment so that we can submit the proposal for the FC's scrutiny. Thank you. Thank you, Mr. Low. May I invite Mr. Jose Antonio Morland, SC from the Bar Association. I declare interest. I am a judge as the CF Court of First Instance. We support the upward adjustment of judicial remuneration. One important principle is to ensure that the remuneration is attractive enough to attract talent. We are concerned about the difficulty in recruitment for judges, especially at the Court of First Instance level. The establishment should have 34 judges, but there are only 25 serving judges. At the same time, the workload and complexity of cases are seeing a trend, an increasing trend. We have received a lot of cases litigated by mainland or overseas litigants because of our status as an international dispute resolution center. The more complicated cases require more time to prepare, as well as for writing a judgment. That's why we support the proposal to increase the remuneration for JJOs. Thank you, Mr. Moreland SC. Mr. Tong from the Law Society. Thank you. We understand that in considering the judicial remuneration adjustment, there is a basket of factors to consider. As the legal body, we consider this is very important. Remuneration is very important in terms of attracting talents to join the judiciary so that the efficiency and capacity in dealing with cases would be enhanced to benefit society as a whole. However, many members told us that the hearing time, the queue for civil litigation is very long. The waiting time is so long that some cases will only be heard in year 2025. So the delay would jeopardize the development of the business sector as well. So we have a very great concern over the overduly long waiting time. National 14 5-year plan supports Hong Kong to become the International Dispute Resolution Center and Legal Service Center in the Asia-Pacific region. In the policy address, the chief executive also said the government would utilize Hong Kong's common law system to bolster Hong Kong's position as an international dispute resolution platform. If legal disputes are not addressed quickly because of insufficient resources, it would undermine our position as an international legal service center. And it would also undermine our competitiveness in terms of disputes and resolution services compared with other Asia-Pacific countries. So we hope that the government can consider remuneration adjustments from the perspective of attracting talents, offer a more attractive package to attract talents, including solicitors, to join the judiciary in the capacity of JJOs and judges to speed up the processing time of cases. Thank you. Thank you. And now we will take questions. 4 minutes, including questions and answers. Dr. Junius Ho. Chair, I support the proposed remuneration adjustment for JJOs, that is 2.5%. There is no question of that. And also, Mr. Roden Tong, the Vice President from the Law Society, has spoken correctly just now. Well, given the level of remuneration, we have to consider the waiting time. It is really too long. Civil litigation hearing dates can be as late as 2020, the end of 2023. That is just a conservative estimation. Well, this is for commercial cases involving disputes between shareholders and also liquidation. Well, the hearing date would be set on 10 days in April 2024. That's how long the wait is. Well, delay of justice justice delayed is justice denied. So we have to be very efficient in terms of handling litigations. I appreciate the underwhelming manpower. There are only some 160 judges from the CFA to magistracies and tribunals. And also we have a succession problem. There are judges who are going to retire soon. That's why 2 years ago we extended the retirement age by 5 years. So do we lack talents, or are we too stringent in the age limit? Is it because the senior judges do not trust the junior judges? And what standard are we looking at in terms of promotion? Well, I think comparison is good for improvement. As I mentioned, I have had 2 court appearances in the GBA. The next one will be in March. Well, my experience is there are tele court services. It is very modernized. And also the transcript would be available 1 hour after the hearing for us to verify. In Hong Kong, if we want a transcript, we have to see the judge, and we have to pay a substantial fee, and the wait is 3 to 4 months. That's too slow. We are not in lack of money. I mean, we are charging a high fee, but we are waiting for a long time. Previously, we were able to cut the waiting time for court appearance from first appearance to hearing to 250 days. There was an improvement. Now the wait is over 24 months. So time is money. The cost is much higher than that in the mainland. It is exponential. So the 2.5% rise is reasonable. But please, give us results. I'm not saying that the judges are lazy. Most of them are very busy indeed. Just another word. Because of COVID, it also contributes to the delay, but we shouldn't use it as an excuse. By supporting the 2.5% increase in remuneration, I hope you can pick up speed. Otherwise, we will lose out on competitiveness.
要現代化。
And also, we should address modernly. We should do away with the wig. This is all reform is about. Thank you.
Thank you for your views, Dr. Ho. Indeed, we have to attract judicial talents. Just by merely raising the remuneration is not adequate. We understand that. Because we're always lagging behind the remuneration of the private sector. So very often we really have to rely on the calling and the commitments of the judicial personnel in order to invite them to join the bench. Any response? Thank you, Chair. Mr. Chairman, you have already explained very clearly. Indeed, remuneration alone is not enough to attract the right talents and committed personnel to the bench and also to the judiciary, especially especially for judges on the level of CFI and above. Indeed, Chairman, you are correct. We do need people who are very committed, who have the calling to join the bench. And that's why we have to consider the factors in a comprehensive manner. And the government has put in resources to the judiciary, and we tried hard to, for instance, improve the working conditions of the judiciary. Vice Chairman, Ms. Yong. Thank you, Chairman. I agree and also support the present proposal of the pay adjustment of the judiciary. Well, I am a practicing barrister. I've also asked my colleagues and peers. I asked why they don't want to join the bench. Many of them said that it's time consuming because for barristers we have more flexible working hours but then if after joining the bench, it may not be that flexible. So this is one of the considerations of the existing legal person in deciding whether to join the bench or not. I hope that the judiciary could be more proactive in soliciting our views. You do have some contacts with us, but actually we have tried to invite you all to come and try to communicate with us, but then it is not very frequent that you would have people coming to us and listen to our views. So I hope that you could be more proactive in communicating with us. I wonder how many senior barristers are interested to join the bench right now. Even though it may not be full-time or long-term, I just want to know how many are interested in joining the bench and what other moves that you could take to attract them. What about for the barristers with some years of experience, which you also try to attract them and invite them to join the bench? This is to ease the problem of shortage of manpower, and also about the simultaneous interpretation services in the courts, or even for people taking down the verbatim draft. And third, assistance to the judiciary. Would we also perhaps add more manpower to the judiciary so that the judges could free themselves more to work on cases? For instance, there are people helping them to collect information and also try to draft some papers and so forth. Well, thank you, Chair. Regarding the third question, whether we could add more manpower to assist the judges to conduct research and draft papers. The judiciary has already started to recruit judicial assistants to assist the judges in conducting research and other paperwork. Starting from 2015, we have this scheme in place, and we have recruited altogether 36 judicial assistants to help out the judges and other judicial personnel in conducting their work. We will continue to recruit people to assist the judges, and the views of Ms. Yong have been taken note of, and we will try to see whether there are further room for improvement. What about from the two legal associations? Any views? No? All right. Next, Mr. Tommy Cheung. Well, Chairman. This is about the pay adjustment for the JJOs. As you've mentioned, that the LegCo has been very supportive all along, and for our party, we are also very supportive, and I have no objection to their suggested pay rise. Well, Chairman, you have put forward a lot of views. I am not very familiar with the judiciary. I actually have no experience with litigation or going to the courts. But after hearing your views, I really believe that the administration should think harder. It's not just about remuneration. We should think of other ways to attract judicial talents to come to Hong Kong. And I believe that the administration has to think harder. All right, this is a comment. Any response? Thank you, Chair. Yes, the point is very clear. And we noted members' views regarding the need and the urgency to attract talents to join the judiciary. We do understand that remuneration is only part of the considerations. We understand that we should improve the working conditions of the judiciary, and administration will continue to work closely with the judiciary in order to attract more talents to join the judiciary. Thank you, Chair. All right, if there are no further questions, I'd like to ask members if you support for the administration to submit this paper or to the Finance Committee for consideration. All right, no objection. Thank you. This is the end of the item. Thank you. I'd like to thank the representatives from the administration and the two legal associations to join our meeting. Any other business? I do not have AOB. All right, no AOB from members. Meeting adjourned. Thank you.